एमएलए कुलदीप सिंह सेंगर जो कि एक कन्विक्टेड अक्यूज्ड हैं एंड जो कि तब एक एमएलए थे, almost walks out of jail after raping a minor girl and after killing her father. The Delhi High Court, even after him being convicted, grants bail. And immediately the Supreme Court, on an application made by the CBI, steps in and stops that order. आइए आज हम जानेंगे कुलदीप सिंह सेंगर के केस में दिल्ली हाई कोर्ट ने क्या कहा और सुप्रीम कोर्ट को क्यों इंटरवीन करना पड़ा। नमस्कार, मेरा नाम अनमोल बरतारिया है और मैं एक प्रैक्टिसिंग एडवोकेट हूं बेस्ड आउट ऑफ बॉम्बे। आइए आज हम समझते हैं कि कुलदीप सिंह सेंगर के केस में दिल्ली हाई कोर्ट ने क्यों बेल दी और ऐसा क्या हुआ कि सुप्रीम कोर्ट को एकदम से इंटरवीन करना पड़ा और उनके रिलीज को स्टॉप करना पड़ा। In 2017, Mr. Kuldeep Singh Sengar, who was the then MLA, was accused of raping a minor girl in Unnao. Now, because of the heavy allegations and because of him being a MLA, CBI was involved and the investigation was transferred to the CBI. After that, the matter was transferred to the CBI court, and after detailed evidence and detailed hearings, the CBI court in 2019 convicted him of grave sexual assault on a minor. Since the trial court thought that he was a MLA, he had a position of authority, even though on the victim, and therefore he was charged under 5C of the POCSO Act, and he was given imprisonment till the end of his natural life. In a separate case, he was also convicted and was imprisoned for 10 years for killing that minor girl's father in jail. Now, after he was convicted, against both of these orders of convictions, he filed two separate appeals. Both of these appeals are pending as of now. Now, in the pendency of these appeals, यानी कि जो conviction हुआ था उसके against जो appeals थी, appeals के pendency में Mr. Sengar filed an application for suspension of sentence before the Delhi High Court on 23rd December 2025. The Delhi High Court, in an application for suspension of sentence filed by Mr. Sengar, came to a conclusion that he will not fall under the definition of a public servant which is mentioned in IPC, and on these grounds granted him bail, obviously subject to some conditions, but he was granted bail. According to me, the Delhi High Court took a very hyper-technical view to say that Mr. Sengar did not have any authority on the child and therefore he will not fall under the definition of Section 5C of the Act. Section 5C of the Act says that if sexual assault is done by any person of some public authority, he will have to be charged in accordance to the rigors of that act. And considering those rigors, the trial court had awarded Mr. Sengar a sentence till the rest of his life, till the rest of his natural life. जैसा कि मैंने आप लोगों को बताया, ट्रायल कोर्ट ने मिस्टर सेंगर को अंडर सेक्शन 5C of the Act कन्विक्ट किया था, and the trial court thought that he was a person of authority, and therefore he being a MLA was convicted as being a public servant and was awarded imprisonment till the rest of his natural life. After that, the Honorable Delhi High Court took a different view and said that no, Mr. Sengar will not be a public servant, and because he will not be a public servant, therefore he is to be treated as a normal POCSO offender under section 3 and 4 of the Act, जिसमें minimum सजा 7 साल है. वो 7 साल से अंदर थे, तो therefore the Delhi High Court took it as a condition and said that Mr. Sengar is not to be treated as a public servant, even though he was a MLA, and thereafter granted him bail. While arguing the application on behalf of Mr. Sengar, the Learned Senior Counsel raised multiple important issues, including the fact that the child was not a child when Mr. Sengar was accused. But the Delhi High Court did not get into this. They left it for the appellate court to decide. However, the Delhi High Court took a very hyper-technical view, in my understanding, on the public servant definition. Now with this, there comes a very, very important question of law. What if you exclude the word public servant from the rigors of POCSO? What happens to the rest of the nation? Is a running MLA not a public person who has some authority over the public? The Supreme Court of India will now have to decide a very important question of law, which is whether a public servant or a MLA, if he does such an act, will he be charged under Section 5C? Will he be a person who has an authority over the citizens of the country, over the citizens of the city or state? Now with this, we can easily notice a big criticism of the Delhi High Court judgment, because the Delhi High Court judgment adopted a very hyper-technical view and said that Mr. Sengar is not a public servant. And this is the exact question of law which has to be decided by the Honorable Supreme Court of India, and this question is definitely going to be of wide national importance. If this is the kind of conversation which you want to be a part of, and if you want to get real life decoding and real life updates about Indian laws and judgments, click the link below, follow this channel on Record with Anmol, and we will keep you updated with the recent judgments, sections and interesting legal topics.